In this lecture, we would like to discuss one of the most important analytical revivalist philosopher of analytical jurisprudence was Professor H.L.A. Hart of Oxford University. In his book, The Concept of Law, he exactly wanted that the legal theory is a system of rules and it would be only explore the relationship between law and society, and that according to H.L.A. Hart, law is a system of rules, and this there are two types of rules, the union of which is according to Hart is the key to science of jurisprudence, and according to Hart, the first one is primary rules and the second one is secondary rules. So the union of primary rules and secondary rules is law, and the primary rules are duty imposing rules, and the secondary rules are power conferring rules, and according to Hart, the primary rules as duty imposing rules were found in pre-legal state, and the secondary rules as supplementary rules to primary rules or power conferring rules found in the legal order, and the union of these two, according to that, is the real definition of law. And as the primary rules are found in primitive small communities in pre-legal state, such as the ties of kinship, common sentiment, and belief, and placed in a stable environment where one could live successfully by such a regime of unofficial rules. And according to Hart, primary rules are those that impose duty upon individuals and are binding because of practices of accepting or acceptance of which people are required to do or to abstain from doing certain actions. So he found certain defects in primary rules, as according to Professor H.L.A. in primary rules, there are uncertainty. One defect he expounded among the defects of primary rules. The first one, according to what is uncertainty, and the second one is that such rules are static in nature. And also the third defect, according to her, they are inefficient or inefficiency in nature. So the first defect in the simple social structure of the primitive small communities are the rules which, according to her, is uncertainty. So the second defect of such rules is the static nature or character of such rules. And the third defect of the primary rules, according to Hart, is that they are inefficient in nature, or the primary rules are inefficient to maintain at the very diffusion of social pressure, and as there is no agency for determining disputes about the rules. So, as regarding secondary rules, which are according to H.L.A. had as found in the post-legal states in the legal world, and those are supplementary in nature, and supplementation of those defects found as remedies to primary rules. So, according to and these secondary rules are the remedies, and according to him, in relation to the defects of primary rules, and that is regarding the first defect, uncertainty, the remedy, according to Hart, is the rule of recognition, and the remedy regarding the staticness of primary rules is the rule of change, and as regarding the third defect of primary rules of inefficiency, the remedy is the rule of adjudication. So, regarding such, Hart himself describes the introduction of secondary rules as a step from the pre-legal to the post-legal or the legal world. So, according to him, introduction of secondary rules are power conferring rules, enabling legislators to change or add, and the judge to determine when the rules have been broken. Has a step forward. So the very introduction of remedies for all these defects is sufficient to bring about a legal system. Law thus can be viewed, according to H.L.A. as the union of primary and secondary rules. So, the very remedy for uncertainty, according to Hart, in his work, The Concept of Law, he calls for the very remedy as rule of recognition, which authoritatively and in the proper way settle doubts as to what the rules are and what their scope is. It stipulates how legal rules are to be identified, to be followed, and enforced within the community. And regarding the second remedy for static quality of primary rules is the introduction of rules of change. So, it would empower certain individuals to introduce new rules relating to the conduct of members of the group and to eliminate the old rules. The remedy for inefficiency or the inefficient nature or character of primary rules. He introduced the rules of adjudication, which confer power on certain individuals to ascertain and to make authoritative pronouncements. So, in short, we could express the very rules of recognition, lay down criteria for identifying the primary rules. The rules of change specify the mechanism for changing primary rules, and rules of adjudication provide for determination whether primary rules have been violated. Most of these rules are directed to the activities of the public officials of a legal system, such as the legislators, government officials, and judges, as these three agencies of a legal system are purely concerned with those supplementary secondary rules like the rule of recognition as under legislation and regarding rules of change those government officials and also regarding the remedy, that is rules of adjudication, to fulfill those defects of inefficiency, as the rules of adjudication by the judges. So, also, Professor Had makes a distinction between primary and secondary rules in his book, The Concept of Law. And there, as he expressed rules of the first type as imposed duties, rules of the second type confer powers. So, the rules of the first type concern with actions involving physical movement or change. Rules of the second type provide for operation which lead not merely to physical movement or change but to the creation of variation of duties or obligation. And so according to Professor H.L.A. Hart, primary rules are concerned with actions that individual must or must not do, while secondary rules are all concerned with primary rules themselves. So, he also explains exactly what is the rule of recognition, as it is the central feature of his positivist theory of law. So, the very rule of recognition, as Professor had expressed that the very answer to the question when a legal system exists, the rule of recognition is intended to already observe, to remove and rectify the uncertainty about what the rules are and the very doubt regarding the scope of any such primary rule. So, according to Professor H.L.A, he made an simple examination of the rule of recognition in English legal system as whatever the Queen in Parliament enacts, it is law. Or where there is a constitution that is accepted, it is the rule of recognition in that society. As, for example, the Constitution of United States of America or the Constitution of India or the constitutions in several countries according to H.L.A, or as they are accepted by the people or considered as rule of recognition in that very legal system. So, he emphasized the very nature of acceptance of these rules. So, also, he made another important contribution, and that is also regarding his validity of law. So, regarding validity of law, also it would be determined by the master rule of recognition. So, also various constitutional laws which constitute the rule of recognition according to her are the rules of positive law, and he finds their authority in the background of constitutional standards. So, Hart's positivism is concerning also judicial decision making. So, court cases are decided in Hart's model by ascertaining what the law is via rule of recognition and applying it to the facts of the case. And so, now we would like to discuss the very difference he made in between law and morality, and so also the similarities in between law and morality. So, in that connection, as Professor H.L.A had system of law, where we found the very implicit of morality. There are several conjunctions in Hart system of law where law and morality, according to Hart, coexist, overlapping, and are even complementary and supplementary in nature. And moreover, Hart rejected Law as a gunman situation further implies that inseparable character of relationship between law and morality. In fact, Hart's positivism has scope for natural law as well as for morality, which has made him both a positivist as well as a naturalist. So, according to Professor H.L.A, Hart, the minimum content of natural law is shared by both law and morals. He further attempts to distinguish morality from law as custom, etiquette, and other kinds of social rules. And regarding that also, he provided four features of moralities. So, according to Professor H.L.A, had among the four features of morality, one is importance, and the second one is immunity from deliberate change, and the third one is voluntary character of moral offenses, and the fourth one is the very forms of moral pressure. So, among the first feature, which is according to Hart, it would be found in case of first moral standards are maintained against the drive of strong passions which they restrict, and secondly in serious forms of social pressure exhorted not only to obtain conformity in individual cases but to secure the moral standards are thought of communicated as a master of course to all in society. So it is an essential feature of any moral rule or standard that it is regarded as something of great importance. It cannot be omitted in any faithful account of the morality of any social group or individual. And as regarding immunity from deliberate change as another feature of Professor H.L.A had as regarding morality. So, it is a characteristic of a legal system according to Had that the new legal rules can be introduced and old ones changed or replaced by deliberate enactment. By contrast, moral rules or principles cannot be brought into being or changed or eliminated in this way. So they are immune from any deliberate change. Why? Any deliberate enactment or legislation. Why the legislature? And the third most important feature is regarding morality, that is, voluntary character of moral offenses, as according to Professor H.L.A. Moral responsibility or blame is a matter of internal matter, while law is generally concerned with external behavior. If a particular person has offended against moral rules or offenses and succeeds in establishing that he did this unintentionally, he is excused some moral responsibility, and to blame him in these circumstances would itself be considered morally objectionable. So, this is the third most important feature of morality as according to Professor H.L.A. had. And the fourth one, that is the forms of moral pressure, a further distinguishing feature of morality, as propounded by Professor H.L.A. had is the characteristic form of moral pressure which is exerted in its support. While the typical form of legal pressure may consist in physical punishment or coercion. So, now we'll discuss the very criticism of Professor H.L.A.'s philosophical contribution to the jurisprudence relating to the primary rules and secondary rules which union is law as Professor H.L.A. had expressed in his major work The Concept of Law, and the main critic of his philosophical ideas and definition of law is Ronald Dawkins' criticism of art. So, Ronald Dawkins makes a distinction between rules and principles, and he seriously criticizes Hart's version of law as a set of rules. He says a legal system has to be conceived as an institution based on certain standards, principles, and policies. As rules are thought as detailed, whereas principles are general. Thus also Professor Patton expressed that there is a vast gulf between the elasticity of general principles such as public policy and rigidity of a detailed rule. And a principle is the broad reason which lies at the base of a rule of law. And so Professor Walker says principles are the broad formulations of reason or generalizations which underlie the comprehend particular rules. However, the controversy about the essence of principle and factual nature of rules does not work in all situations. Knowledge of principle of law without legal rules is sometimes dangerous. So, as Darwin attacks Professor H.L.A. had who holds that the judges have the discretion to create new legal rules through extra legal standards when the existing law is not ascertainable and provides no guidance to the judge to apply the law to certain situations. In this way, Professor H.L.A. had says judges make new rule by using their discretion in strong sense. And Professor Ronald Dawkins rejects this view as incompatible. He says judges do not have a discretion in the strong sense. That is the discretion to appeal to extra legal standards of his own preference. Rather, Professor Ronald Dworkin expressed that a judge has a duty to appeal to certain principles and not to the others on the appropriate occasions and hence involves discretion in one of the weak sense. So Hart's theory, Dworkin argues, does not account for this aspect of official duty. These principles are genuine moral and political principles that judges are duty bound to take into account in their decisions. So, these are the criticisms laid down by Professor Ronald Dworkin on the concept of law that was presented by Professor H.L.A. in the nature of the union of primary rules with secondary rules, as it is exactly the definition and meaning of law. So, in this lecture, we have completely discussed the very idea and concept of law as presented by Professor H.L.A. who could be considered as both a positivist and a moralist. So, in our next upcoming lecture, we would like to discuss about one of the revivalists of natural law school in 20th century is Lon Fuller, and that about his contribution we would like to discuss in our upcoming lecture.